Yes, Mr. Green.
May it please my lady and my lords, I appear in this matter for the appellant with Miss Hannah Gibbs, my learned friends Mr. Village, Queen's Counsel, Mr. Strawn, Queen's Counsel, Mr. Helm and Miss Keating appear for the first and second respondents, and Miss Alison Oakley appears for the third respondent, Darrington, who supports the appeal.
Well, of course they do.
The issue in the case is whether the appellant counsel misunderstood paragraph 90 of the National Planning Policy Framework, the NPPF, in granting planning permission to extend the operational face of Jackdaw Crag Quarry, a limestone quarry in the Greenbelt. Planning permission was granted for a duration of 7 years and subject to a Section 106 agreement with provision for a detailed restoration and management plan as part of the obligations contained therein. The essential factual background is set out in both court's decisions below and in the statements of facts and issues in this court, in particular paragraphs 3 to 10. I propose to take the details of the application as read, although I will be dealing with the decision-making process shortly in some little detail. But I propose to take the following course, subject of course to my lady and my lord's preferences. First, to start with the policy, to look at paragraph 90 of the NPPF, and particularly to examine the relationship.
Perhaps you'd like to spell that out for the benefit of those who are watching you from a long way away.
Yes, I'm going to go to it in just a moment, but
what does NPDF stand for?
The NPPF is the National Planning Policy Framework, and the relevant policy provides that for various types of development, and for present purposes we're concerned with mineral extraction, can be appropriate development in the Greenbelt, and I'll come to what that means in the context of the policy in a moment, provided that it preserves the openness and does not conflict with the purposes of the Greenbelt. So the first question is the relationship between the starting point of that policy and the proviso, and that's where I'll start in just a moment. I will then secondly look at the approach taken to paragraph 90 by the appellant counsel in making its decision, and I say we need to read the officer's report in its proper context, and it'll be part of my case that the Court of Appeal failed to do so, in contrast to the High Court. Thirdly, I'll touch on the relevant case law, and in particular some cases on Greenbelt openness, albeit largely in a very different context to the mineral extraction context with which we are concerned. And then fourthly, I'll draw together my submissions why I say the Court of Appeal's decision was wrong and that there was no error of law on the part of the appellant counsel.
And how would you characterise the point of law of general public importance involved in this case?
When permission was granted, the observation was made it's of general relevance to Greenbelt, but most particularly to the approach taken to mineral extraction. And my submission would be the point of importance is the relationship between the two elements of mineral extraction policy and how those elements that might be seen at first blush to pull in different directions can work together and provide a practical framework for decision making. So I propose to start with the policy context that I hope will set that context. So if the court could please go first of all to MS 917, so it's the Bundle of Authorities, first volume, tab 14. And the National Planning Policy Framework itself starts at MS 914. This is the policy document that was promulgated in March 2012. It has subsequently been replaced, and that's dealt with in this agreed statement of facts and issues, but the Greenbelt policy, this was the policy that applies at the decision, and actually the Greenbelt policy is not materially different in the new version. The Greenbelt section starts at MS 917, section 9 of the policy itself, And I just want to, we're obviously most concerned with paragraph 90, but I do want to deal with this whole section to set paragraph 90 in its appropriate context. So paragraph 79 highlights the fundamental importance that government attaches to greenbelts and the fundamental aim of greenbelt policy to prevent urban sprawl by keeping land permanently open. And the essential characteristics of greenbelt are their openness and their permanence. Paragraph 80 identifies five...
And what does open mean?
So that's the critical issue at the heart. But
isn't that the point of law of general public importance? What does open mean?
We'll see whether it's what does openness mean in every context, or what does preventing, what does preserving the openness mean in the context of prima facie potentially appropriate development. But I would submit that actually the true understanding of openness is the absence of urbanising development. There has been a shorthand in many of the cases that it's synonymous with an absence of development. But what that doesn't grapple with is the type of development, and that's a theme that's explored in the cases, and I will deal with in my submissions, in particular by reference to the Europa case, which is the mineral extraction case I'm going to come to shortly, and also the observations of the Court of Appeal in the Lee Valley case.
I mean, this concept of preventing urban sprawl goes back to the very beginnings in Circular 42 of 55.
It does.
Yeah. In the fundamental aim ever since we started.
Exactly, and the concept of openness hasn't undergone some change when this document was promulgated. It's a well understood, I would respectfully say, open texture concept. So the purpose, as Lord Conworth correctly observes, the purposes, which is paragraph 80, are unchanged from all previous guidance, and I respectfully say they can be encapsulated by the concept of urban containment. Now, paragraph 81 is worth just looking at shortly. I may need to come back to this in the context of dealing with some point of detail on the Turner case, but I do invite attention to the fact that once green belts have been defined, there is a policy to plan to use them and to utilise them for public access and visual amenity. But the critical point, or a critical point, is that the purposes are not focused on visual amenity per se. We'll come on to a discussion about the extent to which it's inherent and the extent to which this case turns on that. But the purposes are focused on separation and urban containment. Paragraph 81 speaks to the need to have an additive value once the green belts have been defined. And there is a difference there that we'll see in a moment by reference to PPG 2. So then there's a suite of policies I don't need to spend time on dealing with the identification of green belts, but obviously we've got an identified green belt here. So in terms of understanding the guidance, we can go over the page to paragraph 87, which is, again, a signal of some continuity here. As with previous greenbelt policy, inappropriate development is by definition harmful and should not be approved except in very special circumstances. So the basic point is the concept of very special circumstances is linked to the level of justification required for inappropriate development. The issue here is whether we are dealing with inappropriate development or not. The council decided that we weren't because they were satisfied that the proviso was applied, and it's the legality of that exercise that's at issue in this court. So analysis in the decision-making process, the question of very special circumstances doesn't arise. 88 deals with how you approach very special circumstances, so important guidance but not in issue. 89 deals with the general rule that the construction of new buildings in the green belt is inappropriate as its starting point, subject to exceptions, and the Court of Appeal in cases such as Timmins has expressed the view that that is, under the NPPF, a closed list, and the court may want to notice the difference in the expression of some of those provisos. So the first bullet point is a category without any qualification. The second bullet point is a category where the phrase that we're concerned with for present purposes in relation to paragraph 90 preserves the openness of the greenbelt and does not conflict with the purposes of including land within it is common to the structure of paragraph 90, so some similarities there. The third bullet point is looking at a comparison with the size of the original building. The fourth one, question of materially larger, which is brought back from NPPG2. No qualifications other than limited infilling in relation to the fifth bullet point, and then a slightly different proviso in relation to the sixth bullet point. So the one that's closest to paragraph 90 is the second bullet point, but the short point is each of those exceptions has their own test and their own focus, and one is looking to a limited exception to a basic rule that new buildings are inappropriate as the starting point. That contrasts with the way in which paragraph 90 is framed. Paragraph 90 says certain other forms of development are not inappropriate. There's a clumsy double negative there, but the Court of Appeal, in the case Lee Valley, has said not inappropriate equals appropriate. So as a...
That's a major step forward.
Yeah, well, at least it removes the clumsy double negative, and we are talking about development that can be appropriate subject to the proviso, and the proviso is preserves the openness of the greenbelt, does not conflict with the purposes of including land in the greenbelt. And then it is relevant to notice the nature of those bullet points. We're concerned with mineral extraction, so both new mineral extraction and mineral extraction that extends an existing facility. This proviso then applies also to all types of engineering operations, and then transport infrastructure that can demonstrate requirement for a greenbelt location. So examples of that would be a park and ride scheme, a bus shelter, or a small bus interchange infrastructure. Then there's the reuse of buildings, and then there's development brought forward under a community right to buy order under the Localism Act. Now, the point of all of those is that one has to contemplate, for this policy to have any meaning at all, the type of development that is potentially appropriate coexisting with the application of the proviso. And it's that relationship that creates ambiguity and uncertainties that need to be grappled with between the starting point and the proviso that is at issue in these proceedings in relation to mineral extraction.
But doesn't the first bullet point contemplate that mineral extraction can, in some cases, conflict with the purposes of the Green Belt?
Yeah, absolutely, it does. It doesn't give a blank check at all. And my lord, I'll go to where that comes from, but it is not contemplating in making it potentially appropriate a fanciful situation. It's contemplating a situation commonly encountered in a mineral extraction development, I would respectfully submit, and I will say there's very helpful guidance that I would invite this court to adopt from the High Court in the Europa case that I will come to on how that proviso and the starting point can work in a practical context.
I mean, mineral extraction may be largely underground.
That's true that it may be, but this is a difference between the parties on the written cases. I say it's a mistake to contemplate that you can only have potentially appropriate development for a largely subterranean provision, because I will be saying and showing the court by reference to the cases that the temporary nature of the development, the restoration provisions, matters of that nature are relevant to the question of whether it's appropriate. So I take the point you could have largely subterranean, but my submission is that for this policy to be workable, it's not contemplating, as the respondent put it in paragraph 9 of their case, I say wrongly, that you are only dealing with, or predominantly dealing with a subterranean position.
I live in an area which is absolutely littered with sand and gravel quarries.
Yes.
Some of them worked out and restored, and some of them still working.
Yes.
But that's clearly mineral extraction.
Yes,
and many of those are in the Green Belt.
Yes, and I say there's no necessary conflict with the question of openness properly understood or the purposes of the Green Belt, and I'll show the court why I say that in just a moment.
Just before you move on from 90, can I just ask, I wonder whether your expression of the Green Belt just being about urban containment can live with what I thought you accepted, that the first bullet point in paragraph 90 contemplates that in some circumstances, mineral extraction may conflict with the purposes of the Green Belt.
Well, can I give my lord an example as to why there's no necessary conflict there? So if, for example, the situation of the mine, so let's say we had either a new mine or extension was sensitive, so that actually giving that over to a form of development would erode the relationship between settlements, for example. So it would lead to there being a lack of a gap that's of one of the strategic purposes. Then that would be a case where one would need to evaluate the relationship by reference to those purposes.
So is that a way of saying that the mineral extraction may itself encroach on the countryside in a way which conflicts with Green Belt purposes?
That's capable of being a judgment that's arrived at. Right. But it's a judgment that needs to be arrived at by a range of factors, and my submission will be that the factors that were taken into account here were the right and was a rational approach taking account of the relevant factors in this case.
What sort of engineering operations might be contemplated here?
Well, that's a very broad concept. I was going to go on to set this in context to PPG2 to show where that comes from, but effectively the answer is any form of engineering operations. Engineering operations is obviously part of what is defined as development. So,
well, I know. One's got to remember the proviso is applying to
all of them. Yes.
Some it may be more relevant to than others. And I mean, engineering operations is such a broad concept that I can see you would need some sort of limit on it.
Yes. Can I go to? Obviously, we're going to be exploring this relationship critically, but I want to set a tiny bit more context before perhaps continuing that discussion to the extent it will assist, which is within the MPPF. If I could ask the court to turn to MS 920, there is a policy, a suite of policies on mineral extraction, but most materially for present purposes, it says minerals are essential to support sustainable economic growth. This is paragraph 142. And quality of life. It's therefore important that there's a sufficient supply of material to provide the infrastructure, buildings, energy and goods that the country needs. However, since minerals are a finite natural resource and can only be worked where they are found, it is important to make best use of them and to secure their long-term conservation. Now that policy, I say, sitting alongside the proviso, is the explanation or part of the explanation, because this dates back to a previous policy suite, of the observation that my Lady Hale made, that she's familiar with areas of the Green Belt where there are a large number of mines. Well, part of the reason for that is because minerals policy has always acknowledged that minerals can only be worked where they are found, and that there is an imperative to make best use of them. So that's part of the balance that informs the interplay between the starting point and the proviso for paragraph 90 dealing with mineral extraction. Now, this hasn't come from nowhere. It's come from, as my Lord Carnwath observed, a long history of Green Belt policy. So I do want to go back to the position under the PPG2, which is the next tab along, tab 15, and which, if I could invite the court to go to, first of all, to MS 936.
So this was in operation from what time to what time?
From 1992. So actually, so this, let me just...
This is 2006
This is a 2006 version, but this replaced, on MS 928, there is a...
1988.
There's a 1988 version. So this version is a reprint of 2006. There were amendments. I'm not aware that the provisions that we're concerned with were changed, but that is something we could agree.
Yes, I'd be interested to know when there was a specific policy for minerals in the green belt.
Yes.
You don't find it in Circular
When it first came in.
When it first came in.
Can I do, I can't help with chapter and verse on that now, but I do think it's important to see what the PPG2 did. And this obviously was the provision. So this version is from 2006, but my understanding is that this has greater longevity than that, and we will check and agree a history on that if that would assist. If the court goes to MS 936, paragraph 311, that there is, and this is obviously a greenbelt policy, the position in relation to minerals is minerals can be worked only where they are found. Their extraction is a temporary activity. Mineral extraction need not be an appropriate development. It need not conflict with the purposes of including land in the green belts, provided that high environmental standards are maintained and the site is well restored. And then there's a reference to mineral policies in development plans and should achieve planning conditions for mineral working sites within the Greenbelt, achieve suitable environmental standards and restoration. And then there's a reference to paragraph 313. Before I go to 313, one thing to notice there, express reference to it being temporary, not necessarily inappropriate development, and need not conflict with the purposes, and answer, well, at least an indication in relation to the point my Lord Sales.
Yes, it's the same point, that sometimes it may...
It sometimes may do, but it need not necessarily. One thing to notice that we'll have to come to is that there is no indication of a relationship with openness being a relevant consideration in this policy. Now, I say that change was noticed and a practical framework was developed in the Europa case that I'm going to come to in just one moment. But
you get it in relation 312 in relation to engineering operations and other changes of use. Where that's why the point I was making about in the new policy they're all brought together, but at this stage openness is seen as something specifically relevant to engineering operations,
but not to mining. And my Lord is exactly right. They have been grouped together in paragraph 90, and in terms of where what's being grouped together comes from, the minerals comes from 311, the engineering comes from 312, and some of the others have been inserted in as new exceptions. So we haven't got the document, but there was an impact assessment on the change, and two of the provisions that are in paragraph 90, one of which is the local infrastructure, transport infrastructure, one of which is neighbourhood plans were specifically identified as changes. So there has been a grouping together, and that may not have been deliberate, but obviously the issue of law is whether that creates a fundamental change of approach or whether the type of factors that are expressly identified in paragraph 311 in PPG2 remain of relevance and assistance in terms of the approach under the NPPF. So I did say that I would come to 313 because it's expressly referred to in 311. My submission on that, it's highlighted in the respondent's case, my submission on that is 313 doesn't actually assist. What it does is it's a general policy for large-scale development, be it appropriate or inappropriate, expressly including mineral extraction, that you should try and achieve as far as possible the objectives for use of land in the Greenbelt. So it's a qualified obligation to do it as far as possible. We need to understand those objectives, which takes us back to 1.6 on MS 930. Now, those objectives are matters such as securing conservation interest, retaining attractive landscapes. So those are actually the part of the NPPF that, if you like, mirrors those is paragraph 81. Once a green belt has been identified, it's good to do the following to improve access and to improve facility. But very importantly, under the PPG2 paragraph 1.7, it said the extent to which the use of land fulfills these objectives, i.e. the objectives in 1.6, is not itself a material factor in the inclusion of the land within the Greenbelt or its continued protection. So there's a clear prioritisation of purposes over objectives and it's very clear in PPG2. It's not as clear on the drafting of the MPPF, but my submission is that same structure is there and to be understood from the purposes being paragraph 80, the urban containment points, I say, and then 81 is the successor to the objectives, which are useful to have. Once you've sorted out your green belt, it's good to make use of it, but they're not fundamental to the purpose of its protection or its designation. So trying to draw those threads together, if I can, may I make the following observations. Under both the MPPF and PPG2, purposes have a higher status than objectives. For mineral extraction, it's not precisely the same test under paragraph 90 as it was under paragraph 311, because PPG2 accepted that mineral extraction could be appropriate, and then pointed to it not conflicting with the purposes, and gave a positive indication that really it was looking at high environmental standards and restoration ordinarily as the critical questions, and it didn't have a test of openness at all in the PPG2, preserving the openness in the PPG2 policy. A change has been to group together a disparate range of considerations in terms of engineering operations and mineral extraction in the MPPF, and to leave a tension to be resolved between the starting point of potential appropriateness and the proviso. So that's where we are with the codification or the new apparently simplified policy. Now, helpfully, I submit, there is clear guidance on how the proviso and the starting point can work from the High Court in 2013 in mineral extraction cases, and that is the Europa case, and I place very substantial reliance upon that in terms of being correct as a matter of principle and workable as a matter of practice. And so, although I said I'd go to the case law in part 3 of my submissions, I take this case first because I submit this is actually a clear, ready-made solution for how this proviso can work practically and sensibly in practice. So it's tab 1 of the bundle of authorities at MS 643.
As far as is this the first? It seems rather surprising that if this is the first authority on mineral extraction in the Green Belt, considering how contentious one might have thought it would be.
But that may be right. That this is the only authority that our researchers have identified, apart from the present case, on mineral extraction under the MPPF. Now, the test was different, or was expressed differently.
No, but I'd be wondering, as far as you know, there's no sort of helpful authority before this.
Well, there's certainly nothing dealing with openness, which is the focus of in a sense, the contentious issue on the facts of this case. But
all right, no, that's right.
Europa does deal with openness, and I put it very much at the forefront of my submission. So the issue in Europa, so this is a decision of Mr. Justice Ousley in the Administrative Court. The question was the status of an application for an exploratory drill site, and the inspector had decided that that wasn't mineral extraction under paragraph 90 of the MPPF, and Mr. Justice Ousley held that that was an error, and that there had been an error in approaching the development as inappropriate development rather than as potentially appropriate development. So that's the context. May I take up a few references in the judgment itself to identify the most important paragraphs. So if we could start at paragraph 20 on MS 650, just to show that that's where Mr. Justice Ousley is identifying paragraphs 89 and 90 of the MPPF. And then having identified them, he then goes to PPG2 through the prism of the development plan policies of the mineral plan. But if I could pick it up at 27, At 27, he notes that paragraph 312 of PPG2 contrasts engineering and other operations and material change of uses, which are inappropriate development unless they maintain openness and do not conflict with the purposes of including land in the greenbelt. I note that it would appear that the PPG2 policy, which underlines the development plan, takes a different approach to mineral extraction from that it takes to engineering and other operations and material changes of use in terms of what's appropriate or capable of being appropriate and what makes it appropriate. That is a different approach from the NPPF. So he notices that there is a difference in the terminology between the PPG2 and the NPPF in relation to mineral extraction. He then, in the judgment that I foreshadowed that the critical issue in terms of whether the inspector had erred was whether exploratory work was treated as mineral extraction. The court can see that just by way of overall context at paragraph 31, the issue is identified. So it became apparent the first and crucial point concerned whether development proposed was for mineral extraction. There's then a discussion of that, and it leads to the answer at paragraph 51. The proposal was for mineral extraction on each of the policies, and therefore the inspector had erred. And then the passage in which I rely and commend to the court is in the context of looking at the effect of that error on the decision-making applying effectively the simplex test. And so that section starts at paragraph 57 of the judgment under the heading of the effect of the inspector's error. The critical passage, which is set out in everybody's case, is effectively from paragraph 64 to 68, and the court will have seen it in everybody's written argument. So in 64, the critical point that's made is that there is nothing inherent in the works generally or commonly found for extraction which would inevitably take it outside the scope of appropriate development in the green belt. 65 I would characterise as being a proposition that the proviso can't swallow the starting point of the policy. So extraction is not generally devoid of structures, engineering work and associated buildings. The policy was not designed to cater for a fanciful situation, but for those generally encountered in mineral extraction. And my submission is that includes open cast mining. It's a policy designed to cover all types of mineral extraction. It doesn't say subterranean or predominantly subterranean or something of that nature. It's a policy applicable to mineral extraction generally. Paragraph 66 is the critical insight that when thinking about appropriateness, preservation of openness and conflict with the purposes of the greenbelt, one can't only think of the size or physical composition of the development at issue, but one also has to reflect upon the purpose of that development. That's made very clear in paragraph 66. And then it's brought home in terms of mineral extraction by focusing on the duration of the development, the reversibility of the effects, and in particular in paragraph 67, the fact that mineral extraction can only take place where the minerals are found. Minerals can only be extracted where they are found. And paragraph 68 then makes it clear the duration and reversibility is a relevant factor for the judgment, and that it is a more complex question of consideration in the green belts. So my submission is that there is a potential problem in terms of what does the new grouped together approach in the NPPF paragraph 90 mean, and how does it live with what the position before was. There was that potential problem. That problem was noticed by Mr. Justice Ousley, and he gave very clear guidance about how there can be a workable framework for approaching the proviso in a way that is fit for purpose for the types of situation generally encountered in mineral extraction. Now, the case went to the Court of Appeal on on the issue of whether it was mineral extraction. And my Lord Kitchin may recall being a member of the court of that Court of Appeal, and the judgment didn't deal in detail with these paragraphs because it wasn't the primary issue. But at paragraph 41, MS 672, there is an observation from Lord Justice Richards that he agrees with the general thrust of the judge's reasoning without needing to consider every detail of it. That's the start of paragraph 41. And then he makes some observations about the fact there would be a very different mindset if potential appropriateness had been recognised in the latter part of that paragraph. So that I say is the guidance that exists in the lower courts on the proviso and mineral extraction under the NPPF. And as part of my submissions, I commend that guidance as giving a workable balance that has some continuity with the factors that were expressly identified in PPG2 and solves in a workable way the tensions between the starting point and the proviso of that policy. Now, I'll come back to whether there is further law in the courts below that displaces that, but my essential submission is that there isn't and there shouldn't be. But may I then move to the second part of my submissions, which is to look at the approach that was taken to the decision-making on the facts of the present case. And I will obviously deal with this as shortly as I can, but there are three factual references in terms of the decision-making process that I do need to take the court to. So as is clear from the judgments below, and the court will have seen, the officer's report, which commences at MS 290, is a extensive document, and the early parts of that report follow a structure that will be no doubt familiar to the court from looking at planning officer reports, identifying the background, site description, the planning history, the nature of the proposals, setting out in some detail the nature of the consultations, and in section 6 identifying in broad terms the applicable policies. And then in section 7 at MS 350 is the heading planning considerations, which is the heart of the analysis that obviously draws on the earlier sections, but this is where the balance is set out. So in the interest of efficiency, I propose to pick it up at MS 350, section 7, and just to signpost where I need to take the court in the context of the range of planning considerations that are considered. So at 7.1 on page MS 350, the court can see a series of bullet points of the material considerations. And the ones that I'm going to say something about shortly, there are three of them, are the landscape impact section, which is a fourth bullet point, the restoration section, which is the sixth bullet point, and obviously the greenbelt section, which is the ninth bullet point and is obviously the most critical, but it has to be read in the context of those two preceding sections. So can I then deal with the factual points so far as I need to in that order? So the first heading is the landscape impacts, and if the court can pick this up at page MS 357, the heading landscape impact is at paragraph 737 of the officer's report. And there was a fairly lengthy consultation process and a number of environmental statements that were undertaken. If I could pick up, this section is the analysis of the officer drawing on the analysis of the landscape architect. So can I pick it up at 742, where there's a reference there to some concerns expressed by the county planning authority's principal landscape architect of a view that the quarry extension would still result in an exposed face close to the skyline, which is likely to be as visible as it is at present, if not more, and would be closer to Warren House Farm and cottages, where there would be less benefit from the restoration of the existing quarry. So that's an observation about the visual relationship of the proposal during its operational phase, during the time that there would be active mineral extraction on the site. There is then at 7:43 reference to the mitigation measures, and at 7:44 there's a concern expressed in the consultation response that the landscape character and quality would be permanently changed. Now, when we come on to the Greenbelt analysis, we need to recall that the Greenbelt is not about the quality of the landscape, but that is a factor that is relevant here to the landscape analysis. But at all events, and so I'm sorry, the other reference I wanted to mention is there's reference to bunding at the last paragraph of 742, and the effect of bunding that's discussed is that it might cut off long-distance views that are currently obtained.
Sorry, could you help me? What does bunding mean in this?
Bunding would be a structure of earth that would effectively provide a degree of screening.
A sort of shield of some kind.
It's earthworks, isn't it?
Yes,
It's a sort of...
Earthworks, usually grassed over.
Yes. So, and there may be a question there as to the extent to which that's a relevant factor in terms of views. So, for example, the extent to which views and openness are synonymous. So one observation I would make is one wouldn't have a view through a forest, but a forest would obviously be open. So there clearly would obviously be consistent with openness. So the equation, which is a step in the analysis that's put forward in a rather undifferentiated way in the respondent's case of equating views to openness, is not right. Now, I'll come on to what's considered, but that's one of the points that's relied upon, effectively, that this would effectively be detracting from openness. So I draw attention to where it's referenced there in the document by reference to the bunding. Now, importantly, at 7:45, the landscape architect makes it clear that they do not object to the proposed development outright. And then there's a discussion of the pipeline, which I don't think is relevant. But just for context, there was a debate about what would happen with a pipeline that needed to be diverted, and it was secured through a Grampian condition, which is a condition that requires something to be done before the permission could be implemented, and that, it was generally felt, would allow for a better solution to the landscaping when the pipeline was diverted. So it's a major focus of the officer's analysis, but it's irrelevant for present purposes other than just to understand that to the discussion in the case. So the landscape analysis is there's no objection to the permission outright, and it's considered that the proposed screening could protect the environment and reciprocants and conforms with the development plan C747. Now, I mentioned that, and obviously because it's relevant, but also because it's I would respectfully submit necessary to note that there is no reference at all in this section of the officer's report to the reason for there being no landscape objection being that there is harm which is outweighed by social benefits. That's entirely absent from the section that I've just taken the court to. Now, I mentioned that because the respondent's written case mistakenly asserts that the officer's report concluded that there was harm outweighed by social benefits. And just for the court's reference, that's paragraph 14, 41, 48, 111B, and 121. Now, that's not what the officer's report says. Now, the error has actually crept in through the courts below rather than the respondent, and I'll show you where it comes from. So error creeps into the analysis at paragraph 26 of the High Court's judgment, which is MS 264, where the point about social benefits is attributed to the officer's report. That's not quite right. So what's said there by Mr. Justice Hickenbotham is not quite right when we read the officer's report. And that error is replicated in paragraph 47 of the Court of Appeal's judgment. Now, so, which is MS 250. I have in mind there the fifth or sixth line of paragraph 47. Reference to the social and economic benefits of continued mineral extraction on the site. And it then references the minutes, and I'll take you to the minutes, but my point for present purposes, that's not what the officer's analysis said. So the source of the error, which comes from an adoption of Mr. Justice Hickenbotham's shorthand, is it's actually an imperfect summary of paragraph 25 of the first and second respondents' High Court skeleton argument. And the balance of the point, such as it is a point, actually is to be drawn from the minutes. So I have to show you the minutes, but the critical point for present purposes is that's not the planning balance at all identified in the officer's report.
So can I just check, in paragraph 47, what you've shown us is a quotation. Is that from the minute rather than the...
Well, no, it's actually from paragraph 26. There is something in the minutes my Lord needs to seize on, but in paragraph 47, the quote is from the judge.
Ah, right, I see.
The quote is from paragraph 26 of the judgment.
Yes, I see, yes.
Which is why I said it's replicated in paragraph 47. So what one needs to understand to get the facts right, and I'm sorry this is a point of detail, but it does seem to be relied on quite vociferously in the respondent's submission. So I do want to have the court to have the precise factual basis in mind. The officer's report, as I said, doesn't talk about social benefits at all in terms of the landscape analysis. There is a bit of the minutes that I need to show the court. So the bit of the minutes that I need to show the court is at MS 404. Under the heading landscape. Now, the third...
These are the minutes of the discussion of the report, is that right?
Correct, of the planning meeting,
yeah.
which had the report, and then there was an oral discussion, and then there was a resolution, and we'll see what the resolution said in just a moment, but this was of the discussion at the meeting itself. So the third bullet point is the County Planning Authority Principal Landscape Architect has some concern surrounding the continuing extraction up towards the ridge. This was demonstrated on the photos on the committee presentation. However, no objection has been received from the principal landscape architect. Full stop. That's a completely accurate summary of the section that I've shown you of the officer's report. There is then this next bullet point, which is the source of the contention that it was all about being outweighed social benefits. So it starts with the word nevertheless, and then there is a discussion of the need of some advice that there's a planning balance between the impact of the development on the locally important landscape area and the social and economic benefits of continued mineral extraction on the site. Now, it clearly isn't right to read the minutes as if they were a statute. My submission is that the nevertheless means something along the lines of, in any event, there would need to be a balance. So here's the advice. There's no objection. In any event, if there were problems, there'd be the need for a balance. So my submission is nothing in the officer's report, and this doesn't displace the analysis in the officer's report. Now, in order to set the minutes in context, one also has to take account of the fact that MS 405 under the heading restoration, there's again reference to no objection from the landscape architect. And then there's a heading conclusions at MS 407. where it's said in terms in the third bullet point, some concerns but no objection. And then finally, when one gets to the resolution is unequivocal at 409. That's subject to the signing of a 106 agreement controlling the long-term restoration, aftercare and management of the site and appropriate lorry routing. Planning permission be granted for the reasons stated in the report and subject to the conditions outlined. So a fair reading of the minutes on their own is consistent with what the officer's report says. A fair reading of the officer's report, there's no reference to social benefits at all. And I would respectfully submit these minutes can't displace the analysis in the officer's report, because at the operative point is the decision is expressly referred back to the decision in the officer's report itself.
I'm so sorry. Where on 409 was?
Oh, I'm so sorry. Do you see resolved, my lord?
Resolved, yes.
And then planning permission is granted for the reasons stated in the report.
Yes, thank you.
So,
this point founds on paragraph 747 and what it says, as I understand it.
Yes.
Your point.
Yes.
But I mean, I think that there are, in 747, there's save policy 4/1. There's save policy ENV9, and there is policy SP18. But I think of those three policies, the so ENV9, I think is the only one which has any question of balancing, because at paragraph 6.86 at MS 348.
348, I'm great, very grateful.
Proposals for development of certain nature reserves, etc., will not be permitted unless there is no reasonable alternative means of meeting the development need, and it could be demonstrated that there are reasons for the proposals which outweigh the need to safeguard the intrinsic local nature conservation value of the site or feature. But it's not clear to me, just at a glance, whether policy NV9 is directly applicable to the site. But it seems to be a balancing policy. I mean, does the site meet any of those criteria of local nature reserve or site of local importance for nature conservation?
It is a site of, there is a local nature conservation issues in play. But my lord, the analysis of no objection is not just in 747, although that's where it's drawn together by reference to policies, but it's also 745, where there's no mention of the relevant balance being part of that. The reason that there's no objection is because the litigation is satisfactory overall.
Yes, there's just a list of policies there, and you say the fact that one policy refers to balance doesn't affect the reasoning that goes before.
No, because the reasoning, the substantive reasoning. My only point is that substantive reasoning doesn't rely on the outweighing balance. So I apologise that that's a point of detail, but it is, I would respectfully submit, important to get it right, because it features both in the Court of Appeals analysis and in the respondent's primary case. The second of the three factual references I want to take up is under the heading of restoration, and that's at MS 363. And there's a sizable section of the officer's report dealing with the proposals that were secured by section 106 for the restoration of the site. And if I could, that starts at 363, if I could pick it up at 364 7.79, there's the need for there to be adequate restoration proposals flagged up by the principal landscape architect there. And then there's a discussion at 781, paragraph number 365, of the proposed restoration scheme and what will be required in terms of the 3 bullet points at 781. Now then, materially for present purposes, there is a record of an objection from the first and second respondents. SSOBT is Samuel Smith, Old Brewery of Tadcaster, who are concerned about the restoration proposals, saying that it's the appellant's intention to largely leave the quarry in its work state without restoring the site to its previous landform level or appearance is entirely unsatisfactory. So the complaint is that effectively, because there will be a change of levels when it is remediated, that is unsatisfactory, and it is said that that is objectionable for a number of reasons, including being inconsistent with the openness of the green belt. The court will see that recorded at 784. Now, that objection is rejected because the judgment is expressed that the remediation scheme that will be secured is sufficient based on the advice from the principal landscape architect, 3C785, and that is then said to accord with a suite of policies, including the NPPF, C787. So the context is there is a gripe about the remediation scheme. The gripe is made by reference to openness on the green belt. It's rejected on the basis of advice that the remediation scheme is appropriate by reference to the NPPF. Now, on its own, that may be a rather opaque way of dealing with it, but the point that's important is that when we come on to the greenbelt analysis, the remediation scheme is absolutely part of the reason for finding that the proviso is complied with. And when one reads that in conjunction with this analysis, one sees that the question of openness is raised as an objection to the remediation scheme, but rejected. And so we then come to the greenbelt section, which is the critical section of the report, and that is to be found at MS 371. At least it starts at 371. 371 identifies that this, 7.117 on MS 371 identifies the sites in the green belt. It accurately identifies the purposes of the green belt in context. Over the page at 7.118, the first sentence of 7.118 contains an entirely accurate summary of paragraph 90 of the NPPF. At 7.121, the officer asks the relevant questions in terms of whether the proviso is met, preserve the openness and ensure no conflict with the purposes of including land within the green belts. Now, an important point of difference between the courts below, the two courts below, is how you then read what follows. The Court of Appeal was, it would seem, almost exclusively looking for the answer for openness in 7.122, whereas by contrast, and I'll show you this in a moment, the High Court took a broader and more purposive approach and thought that the whole of this section was relevant to the answer given to openness. So 7.122 does deal in terms with openness. It's considered that the proposal preserves the openness of the green belt, does not conflict with the purpose of including land within the green belt. Openness is not defined, but is commonly taken to be the absence of built development. Although the proposed development would be on an existing agricultural land, it's considered that because the application site immediately abuts the existing operational quarry, it would not introduce development into this area of a scale considered to conflict with the aims of preserving the openness of the greenbelt. So far, predominantly a spatial analysis that must be informed by an understanding of the nature of what is proposed in order to make the judgments that are recorded there. That is the analysis of openness in that paragraph read in isolation. However, we then get at 7.123 an analysis of the extent of conformity or otherwise with each of the purposes of including land within the green belt. And in the course of that, we have that the development would not undermine the objective of safeguarding the countryside from encroachment, as it should be considered that the site is in conjunction with an operational quarry which will be restored. So the question of safeguarding the landscape is expressly linked with the restoration provisions and the fact that it's a temporary use of land that is being proposed, which will be regulated through the Section 106. 7.124 looks at the context and expresses the view that there's adequate detachment from the various settlements, so there's no threat to that. 7.125 brings in the context of a specific objection focused on assisting urban regeneration, reference to the rural nature of the site, the fact that minerals can only be worked where they are found, and therefore not undermining the Greenbelt aim. And then at 7.126, all of those threads are drawn together to make a conclusion about conformity with paragraph 90 of the NPPF. So the restoration scheme is to be designed and submitted as part of the Section 106 agreement. It's considered that there are appropriate controls to ensure the adequate restoration of the site. Due to the proposed restoration of the temporary quarry and the fact that it's considered that the proposal doesn't conflict with the aims of the Greenbelt, for that you have to read all the analysis above, which talks about minerals can only be worked where they are found, restoration, temporary use. It is considered that the proposed development would not materially harm the character and openness of the Greenbelt, and therefore would comply with the policy. Now,
sorry, I just want to say, on 7.122,
yes.
I would have thought that you could fairly say, although they identify, if you like, the predominant point of openness to be the absence of built development, they don't confine, or the officer doesn't confine herself to that, because she goes on to talk about the impact on openness of what is in effect an open cast mineral extraction site.
And the nature of it being temporary and restored, etc., yes. The purposes point. I do say that, and the primary way I put that is that 7.126 expressly links the conclusion on openness to the analysis, to the restoration, the temporary, and the analysis of the effect on purposes. There's a linking paragraph there. Due to the proposed restoration and the fact it's considered it doesn't conflict with the aims of the Greenbelt, it's considered it won't materially harm the character and openness. So
beg your pardon, you carry on.
So the whole basis on which the Court of Appeal said that visual effects were excluded and this was a purely spatial approach is not actually grappling with the true context of the decision that brought to bear all of those Europa-style factors that are relevant and are much more than spatial considerations. They're looking at the purposes. And I submit you can't possibly form a judgment about it, the temporary nature of it, the restoration, etc., without understanding what it is that's proposed, including the visual elements of it.
Mm.
So, I mean, just on 7.122, I think it's Mr. Justice Hickenbottom speculates that perhaps the officer had in mind the guidance from first instance in Timmins, saying that it was openness was about the spatial aspect.
Yes.
I wonder whether that speculation is right, given what is actually said in 7.122.
Well, my Lord, my submission is that the totality of the analysis of 7.122 read together with what follows is entirely on the piece with the guidance in Europa. And when I'll come on to deal with Timmins, in effect, that's all a sideshow that's not focused on mineral extraction. So it may not be of particular assistance to displacing the factors that we know from mineral extraction context are relevant, which includes the quality of the restoration, the need to deal with minerals where they're found, the temporary nature, and all of those considerations.
Yes. So, as I understand it, then you say that the advice does address each of the 5 purposes in paragraph 80.
Yes.
And you say that so far as visual impact is concerned, it's inherent in the analysis that we see from 7.123 to 7.126.
Yes, but by virtue of the fact that it draws, the conclusions on openness draws expressly on those that purposive analysis, those Europa factors. And also the conclusion is that it doesn't materially harm the character and openness, and that may well contain a visual analysis. But the complaint, the reason this has come in this way is that there's a judicial review, and the way it's put in the respondent's case and the way the Court of Appeal, that there was an active exclusion of the visual component. And the only way you get to that is if you put the blinkers on, I submit, and you only look at 7122 in isolation from the 4 paragraphs that follow it. Now, that's where the difference in approach between the Court of Appeal and the High Court is instructive, because I submit the Court of Appeal did that. They looked only at 7122 in a way that's unfamiliar to the basic approach of reading these reports in context, and that's paragraph 45 to 47 of their reasoning. That sharply contrasts with what Mr. Justice Higginbotham did. If I could just show you his paragraph 63 in the High Court, which is MS 274, where he says, paragraph 63, Mr. Village is with respect not right to say that in respect of the issue of openness, the officer's report considered only spatial impact, because in paragraph 7.117 to 7126 of the officer's report, as the officers were entitled to do, as well as spatial impact, the Europa factors were clearly taken into account in coming to the conclusion at 7126 that the proposed development would not materially harm the openness of the Greenbelt. So he, I say correctly, understood that there was a wider suite of considerations than purely spatial take effect. Now, the truth of this might be that the spatial visual dichotomy is a false dichotomy. And
I was going to ask you about that.
Isn't the amount of space part of the visual impact?
Well, there are some observations. Exactly. How can one truly make a judgment about spatial without also being aware of the nature of what's proposed and the relevance of that?
But I mean, spatial impact, is that a synonym for the scale?
Well, it's more to do with the use of land and the erosion of the buffer and the scale of it relative to what's proposed. It's a land use approach that, so I would encapsulate it as being a judgment that the buffering function of the green belt has not been is not undermined by this proposal, because it said it's a limited extension of an existing quarry, and then it's temporary and it will be restored when one reads the totality of the analysis.
Somewhere I think it's described as area and volume. Is that how you would characterise it?
Well, there is a reference to 2 and 3 dimensions in the analysis. The way I primarily put my case is that Mr. Justice Ousley rightly identified the sort of factors that one ought to be thinking about in terms of this judgment of whether the proviso is met in a mineral extraction case. And it's absolutely clear that all of those factors are truly considered in this analysis. And it's an erroneous analysis to say that visual considerations are excluded, because that analysis only really makes sense if you've understood the nature of what's proposed in visual terms, and you're assessing its impact as a matter of applying a complex policy, well, a simple to understand policy, but complex to apply because of the suite of considerations that need to be applied.
So spatial can involve looking at a map saying the green belt is only X hundred metres in this area, and you're using up Y meters of that X hundred meters. So that's part of a spatial assessment, as well as the visual element, looking at the volumetrics of what is proposed in the greenbelt.
Well, my lord, I would agree with that. So, for example, if you think about the purpose of keeping towns apart, effectively, spread. So if there's a space that's particularly useful and you have a mine there that's visible, that might detract from that purpose. That might be a spatial consideration, potentially, as well as a visual consideration. Equally, if you think about normal development you can't see, but takes away valuable open space that's important to be protected, then that would be, it wouldn't be right to say there's no impact on openness merely because you can't see it.
I mean, 7124 is looking at that sort of factor, the degree of separation between the communities.
Yes.
The officer says, well, there's plenty of separation here, so that's not a big issue.
Yeah, there's no particular spatial
Fairly
sensitivity.
accepting that in another case it might be threatened by even something like a quarry.
Precisely.
Yeah.
Precisely. There might be a particular reason, particular factor why there's heightened sensitivity to a tangible sense of space where seeing something, the purpose of which doesn't automatically offend Greenbelt policy, might nevertheless conflict in the particular circumstances of a case. But that's not this case. So the upshot of that on the facts is I say that the relevant factors are considered and that it is incorrect to find, as the Court of Appeal did and the respondent's claim depends upon, that there was some kind of exclusion of visual effects. There's no direction at all to exclude them. There's a wide range of suite of factors that are considered, and the more natural analysis is that factors such as restoration, scale and character necessarily involve taking account of an understanding of the visual effect of what is proposed. But the overall balance is consistent with the proviso as it's understood and applied in the Europa case. So my lady and my lords, I propose then, that's a second of my 4 headings, to then deal with the case law.
And presumably just on that, you say the conventional approach to reading officers' reports is benevolent construction. You're not going through looking for errors. You're looking to see whether read fairly, they've drawn attention to the relevant facts.
Precisely so, and those are well familiar principles. So in my case law, I've got three headings, but the first 2 are very short. So the first one is precisely that, my lord, the approach to dealing with the officer's report. I don't think I need to trouble the court with going to any of the authorities on it. I would commend, actually, it's very well encapsulated by Mr. Justice Hickinbotham at paragraph 9, little 5, MS 259. I also have to acknowledge that it's correctly articulated in the Court of Appeal at paragraph 33, but my submission is that there was the adoption of an incorrectly forensic analysis in paragraphs 45 to 47 of the Court of Appeal's judgment by focusing on 7122 in isolation rather than in its true context. So that's my first very brief topic that I won't trouble the court by tracing through the authorities. The second one is also the need for there to be the correct approach boundary between interpretation and application. And obviously the court's well familiar with the Tesco and Dundee. And we deal with this, I should say, in our written case at paragraphs 34 to 38. The court will be very familiar with the Tesco and Dundee. It's a matter of law for the court to say what the policy means, but the application of that is a matter for the decision maker. And it might be of interest to note that some of the examples discussed in Tesco and Dundee come from the Greenbelt context. So the question of what materially larger means in Heath and Hampstead is one of the decisions that's referred to, and that was something that needed legally sharpening to understand that concept. By contrast, in the North Haven case, which was institutions standing in extensive grounds, the court in Tesco and Dundee seems to be content with the proposition that those words are readily understandable and how they're applied in any given situation is a matter of planning judgment. My submission is and will be that openness is a readily understandable concept, and it's the application of that concept, which is itself somewhat open texture, but owes itself to an absence of development, but also linked into spatial containment or urban containment, that is primarily a matter of judgment, and a practical framework already exists in the Europa case for so applying. I also have in mind, and it's in the written cases, the observations of my Lord Carnworth in the Hopkins Holmes case about a tendency to over-legalise and the role of the court being relatively limited. And I say, I'm about to say, that the debates about the meaning of openness and the attempt to sharpen it to create a hard-edged concept are actually potentially an unhelpful stepped down the road by other courts, and that there is no need to undertake that exercise. So that's my third topic, the Greenbelt cases on openness.
Well, what is striking is the word openness was used in PPG 2, but neither in the purposes nor the objectives once the Greenbelt was established.
Yes, although it may be said that the 5 purposes are all, if you like, an embodiment of the broad aim of maintaining openness.
Yes, but then you have the oddity of the proviso having 2 criteria, openness and 5 purposes.
Yes.
So, but you say don't over-legalise.
Yeah, my lord, I do. I mean, the way I'd like to put it is this: I'm about to embark on an examination in the rest of my time of the Greenbelt cases so far as they help on this. But before I do that, I'd just like to pause and reflect on the position as it stood when Mr. Justice Ouseley gave his judgment in Europa in July 2013. So at that time, the MPPF had come out, we'd had Tesco and Dundee, and Mr. Justice Ouseley had no difficulty whatsoever in understanding the concept of openness and formulating practical guidance on the range of considerations which needed to be grappled with by the planning authority in order to exercise its judgment as to how that concept applied in mineral extraction cases so as to be capable of working for the type of situations which were generally encountered in mineral extraction cases. It was a well understood concept that was open texture in terms of its meaning, in the sense that applying it to any given facts required the application of a wide range of factors which were matters to which the decision-making of the authority should be given some latitude, subject only to questions of rationality. And the journey that I will embark on shortly, and as efficiently as I can, about openness, none of which is in mineral extraction policy, actually has detracted rather than sharpened the clarity that Mr. Justice Ouseley gave to the question of the proviso in a mineral extraction case. But it's important to recognise at the outset that we need to go to 4 cases to see where the debate has gone, but none of them are mineral extraction cases, none of them are about the proviso. The only mineral extraction case is Europa, and Europa gives a legally correct, practical and workable framework. So I will, because they're debated in the cases and they inform the court below, in those cases, but I do that with that important caveat in mind. So there are 4 authorities that it may be necessary to go to, albeit hopefully some of them can be very brief. So the starting point is the Heath and Hampstead case, which is tab 5, and really it's only the starting point because it's been used in other cases rather than that it's a case that's broadly comparable to the facts of the present case. So there's the first instance judgment of Mr. Justice Sullivan upheld on appeal by the Court of Appeal, including my Lord Carnworth, giving the lead judgment. Now, as I've indicated, it's a different context. So this is about a replacement dwelling in the Greenbelt and the meaning of the term materially larger. And in deciding that there was conformity with that policy for the larger replacement dwelling that was proposed, the council had emphasised in their decision-making the lack of visibility of the larger building to say that it wasn't materially larger because effectively it could not be seen. And it was decided by the first instance court and the Court of Appeal that that was an erroneous approach. And the critical parts of the High Court judgment, Mr. Justice Sullivan, are, and this is probably not doing justice to the reasoning, but just to give the court a flavour of where this debate starts, is paragraph 21 under the heading, he's dealing with an authority that was relied upon in support of a different approach to materially larger. Surrey Holmes, my conclusions, and at paragraph 21, he says, paragraph 3.6.
Could you give us
an
electronic page?
I'm so sorry. So paragraph 21 is at MS 724, my lord.
And where's the first page of the report?
Oh, I'm sorry. The first page is 714.
714.
I apologise for the omission.
715, I think.
Sorry, 715. My lord's quite right, 715. So 715 is where Mr. Justice Sullivan's decision starts. Paragraph 21 is the part of it where he's opining on the approach to replacement building. So he says paragraph 3.6 is concerned with the size of the replacement dwelling, not its visual impact. There are good reasons why the relevant test for replacement dwellings in the Greenbelt and metropolitan open land is one of size rather than visual impact. The essential characteristic of Greenbelts and metropolitan open land is their openness. The extent to which that openness is or is not visible from public vantage points and the extent to which a new building in the Greenbelt would be visually intrusive are a separate issue. And then he draws attention to 315 of the Greenbelt dealing with visual amenity. Now, the context for those observations are him deciding that what matters for materially larger is predominantly the size of the building.
So what does materially mean?
Well, that's answered in paragraph 44. I think we'll assist on that, my lady, or at least I hope it will. So what the passage that's criticised from the committee meeting is one that talks about it's not materially larger because you can't see it. And then Mr. Justice Sullivan gives this guidance at 44. The claimant is right to contend that this approach to ask what harm would a particular replacement building do in terms of its visual impact from a public vantage point within the metropolitan open land is the antithesis of the approach which should be adopted when deciding the threshold question, is this replacement dwelling appropriate development within the metropolitan open land? At the risk of repetition, the question is not whether the replacement dwelling would be more visually intrusive from the public realm, but whether it would be materially larger than the existing building. That is principally a question of size rather than perceived size. It is one thing to say that the perception of size may be relevant in deciding whether a measured increase in size is material. It is quite another to substitute an assessment of visual impact for a measurement of size. Although the perception of size may be relevant in marginal cases, the tail must not be allowed to wag the dog. So that's what Mr. Justice Sullivan thought was the right approach to materially larger, and that was upheld by the Court of Appeal. And I hope, without doing a disservice to my Lord Carnworth, I can just deal with that briefly by reference to paragraph 37, where his conclusions effectively supporting the approach of Mr. Justice Sullivan are set out at MS 745. And he says, as with Mr. Justice Sullivan, size is the primary test. The general intention is that the new building should be similar in scale to that which it replaces. And then there may be some need for some qualification about it, but then last sentence, that flexibility does not justify stretching the word materially to produce a different, much broader test, as has been seen where the authors of PPG2 intend a broader test, that intention is clearly expressed. So predominantly a size-based approach. So that is, for what it's worth, the Heath and Hampstead case. Now, the second of the four authorities I need to deal with is Timmins. Need to deal with, not for the purpose of advancing my main submissions, but for the purpose of just seeing where the Court of Appeal's approach comes from in the present case. And Timmins is a case that's to do with the status, so that Timmins at first instance starts at MS 834. It's tab 10 in the first volume of authorities. It's a case concerned with the status of cemeteries under the NPPF. There were, just to set the context, there were two proposals that were considered. One was for a crematorium and a cemetery in the Greenbelt, which was granted, and a proposal for a crematoria, which was refused. And the officer had treated cemeteries as not inappropriate development because he said that they were caught by the second bullet point of paragraph 89 of the NPPF. That's MS 839, where that's set out. and the main issue in the case was that he was wrong to do so because the exception in paragraph 89 was only concerned with buildings. That's the position that Mr. Justice Green arrives at in paragraph 23 of the judgment at MS 841. And so therefore there was a need to have very special circumstances if you are outside paragraph 89 and 90, and there's a debate in this case about whether they are closed categories, and both Mr. Justice Green and the Court of Appeal held that they were. The exceptions that give rise to potentially appropriate development in 89 and 90 are closed categories. One of the issues in this case was there a catch-all category outside of those, and the answer was no. So that's the main issue, which is ground one. The part of the judgment that is potentially of interest for present purposes, subject to the caveats I gave at the outset, is ground two, which is a discussion of openness versus visual impact, and that starts at MS 851. And the challenge that was advanced in this case was that the officer's analysis had wrongly elided, this is from 57 first sentence, wrongly elided the two different concepts of openness and visual impact, and thereby misdirected itself as to the meaning of openness. And there's various passages of the officer's report that are relied upon by, in fact, Mr. Strawn on behalf of the claimants in that case. And one will just to give the context, for example, paragraph 467, the point taken was impact on openness was mitigated by hedgerows. So in other words, relying on screening as effectively reducing the impact on openness, and some more detailed criticisms were advanced in relation to paragraph 470 that's at the top of MS 853. Now, the outcome of this ground was that Mr. Justice Green rejected, in fact, the criticisms of the officer's analysis, but that's the fact-specific bit that doesn't matter for present purposes. But in the course of giving that judgment on that ground, Mr. Justice Green has a section that starts at paragraph 67, the relationship between openness and visual impact. And he reflects upon the Heath and Hampstead judgment and opines that there is paragraph 73, openness and visual impact, he says, are different concepts, yet they can nonetheless relate to each other. The distinction is subtle but important. And then, having drawn extensively from the discussion in Heath and Hampstead, he attempts to encapsulate some general principles in paragraph 78 of the judgment. So he says, in short, it seems to me that there are 3 points which arise from the above analysis. First, there is a clear conceptual distinction between openness and visual impact. Second, it's therefore wrong in principle to arrive at a specific conclusion as to openness by reference to visual impact. And third is a point about very special circumstances that we perhaps don't need to be concerned with. Now, those two principles are the subject of discussion in subsequent cases, because my Lord Sales, sitting in the Court of Appeal, doubts both of those principles in the Turner case. But that's where it arises, where that discussion comes from. For my part, I would readily concede that the wrong in principle to arrive at a conclusion goes too far. It may be that there is potentially some important force, albeit subject to some clarification, that there are conceptual distinctions that need to be carefully borne in mind when thinking about how visual impact bears on openness, not least of which because, as I've tried to articulate in paragraph 60 of the written case, it may well be utterly uninformative. If you have something that's inappropriate but you can't see it, it still has an impact on openness. If you have something that's potentially appropriate, the mere visibility of that without more doesn't actually take you very far in openness, because you have to think about the purpose. If it's temporary, you have to think about how long it will be there and whether it could be restored. So at most, there is the need to...
I mean, it's a simple point. I mean, he's right to say that there's a conceptual distinction between openness and visual impact. I mean, the languages are different, but you would say he accepts that he was wrong to go on to sort of term that a non sequitur, really, than to say that visual impact is wholly irrelevant to openness, which again doesn't seem very sensible.
My Lord, I say one is a correct but incomplete observation, and two, I wouldn't dissent from is a non sequitur, and it certainly goes too far.
I mean, I think my difficulty with both the propositions was that he runs them together. So you see that secondly, he's taking it as a consequence of what he's described as the clear conceptual distinction,
Yes.
that therefore it's wrong in principle, which I think, thinking back to Turner, rather informed what I thought he was trying to say about clear conceptual distinction, that in effect these were hermetically sealed different categories.
Yes.
That's what caused me a little bit of difficulty with the first. It's because he's run it together with what you accept is going too far in the second.
Yes, and if I may say, it's actually an example of the over-legalisation in practice, because here's an attempt to formulate something that doesn't necessarily need to be formulated, which then leads to somebody running a point that entirely, an obviously bad point, that an entirely volumetric approach was all you needed to do to have the judgment about open texture in Turner, which is then rejected because one needs to grapple with that proposition on the facts. But none of that illuminates or helps with where we were pre that whole debate, which I would respectfully say is perfectly well understood by Mr. Justice Ouseley in the Europa case. So that's Timmins.
This is the sort of thing we saw in the Hopkins case, where you get sort of one judgment, which is then trotted out at the next planning inquiry, and then everything sort of gets out of sync. Right?
Yes. So Timmins went to the Court of Appeal. I don't think we need to be troubled with the Court of Appeal. The issue on openness didn't. There was an issue on the structure, and there's some discussion of the structure of the MPPF in Timmins in relation to cemeteries. And the overall conclusion was that cemeteries were outside of it and that they were closed categories. But there's not unanimity of the relevance of the approach to the purposes set out in the objectives set out in paragraph 81 and how they might apply to a potential change of circumstances, because Mr. Justice Mitting, sitting in the Court of Appeal, expressed concerns by reference to the cricket pitch example. But all of that, I just draw attention to the fact there's a debate there, but none of it even tangentially assists, I'd respectfully suggest, for present purposes. But Timmins did go further. So the third of the four cases I just wanted to refer to give the story of how this has been analysed in terms of openness is the Lee Valley case. Again, I can probably deal with this pretty shortly. But Lee Valley concerned an agricultural building under paragraph 89 of the MPPF. So, as the court may recall, the agricultural building exception to new buildings has no proviso attached to it. So the question of preserving openness is not relevant to whether the agricultural building is inappropriate development. But there are some observations about the purpose being relevant to the question of openness in Lee Valley at first instance and in the Court of Appeal that are potentially relevant, and I would say are rightly consistent with and drawing on the Europa case. So that's the reason I go to it, albeit very shortly. So just to try and do this as efficiently as I can, the first instance decision is at MS 747 tab 7. And the relevant, so the conclusion of the judge, Mr. Justice Dove, was that there was no strings attached to the proviso of agricultural building, and so this large glass house was appropriate development because there was no question of a separate test of it preserving openness as part of that first limb of paragraph 89. The court, there's some observations of Mr. Justice Dove in paragraph 61 and 62 that I call attention to briefly. That's at MS 781. So he makes the observation that agricultural buildings are not the subject of any qualification. And he says, secondly, if an assessment of openness is a gateway in some cases to the identification of appropriateness, it's strongly suggestive in my view that once appropriate, the question of the impact of the building on openness is no longer at issue. So that's dealing with how you approach agricultural buildings in the context of the issue before him, where there is no qualification to the exception. And then he says the question is obviously related to the question of what the implications are of a development in the green belt not being appropriate, or in simpler language, being appropriate. The question is, what is the development appropriate to? The answer must be appropriate to the green belt. It follows that appropriate development is deemed not harmful to the green belt, and its principal characteristic of openness in particular, it is appropriate to it. This is the conundrum which is being described by Mr. Justice Ouseley in Europa at paragraph 66, which I have quoted above. The same building in terms of its dimensions may or may not be harmful to the green belt, depending on its use and whether that use falls within the exceptions in paragraphs 89 and 90. All new buildings in the green belt will in truth have some impact on openness, but if they are appropriate in terms of the exceptions in paragraph 89, then they are not harmful to the green belt. This approach and understanding of the policy answers the points advanced by the claimant. So the point
that really helpful. It sounds a terribly complicated way of put with great respect.
It may be the point. It may be itself another illustration of overcomplication. The reason I draw attention to it is it draws on the insight in Europa that the purpose of what you are seeing is relevant to the analysis.
I mean, that's obvious in the policy.
But if that's obvious, then then it doesn't assist. But that's the reason I'm going to it. But partly also because Mr. Justice Lindblom, sitting in the Court of Appeal in the Lee Valley case, upheld that approach and expressly drew upon it. I just draw, I take my Lord's point that this may not be of great assistance, but the relevant paragraphs just to note are paragraph 7, MS 792, where at that stage he's referring to the case law, including Mr. Justice Green in Timmins, and perhaps more relevantly is the discussion later on where the court might want to just note paragraph 19, which is a discussion of the approach in agricultural buildings, but then perhaps most materially at paragraph 24 and 25, Mr. Lord Justice Lindblom expressly endorses the observations of Mr. Justice Dove at paragraph 62 in paragraph 24, and in paragraph 25, this is MS 799, he says, Mr. Justice Dove saw support for this conclusion in the judgment of Mr. Justice Ouseley at first instance in Europa. I think he was right to do so. Mr. Justice Ouseley captured this point well when he said at paragraph 66 that under the policies in paragraphs 89 and 90, considerations of appropriateness, preservation of openness and conflict with greenbelt purposes are not exclusively dependent on the size of the buildings or structures, but include their purpose. Now, that's of relevance because my submission is that a purpose-based approach to impact on, amongst other things, openness is entirely absent from the analysis of the Court of Appeal in the present case in a way that's inconsistent with Europa. So,
but it's odd because this is Lord Justice Lindblom who, perhaps as much as anyone, has been sort of formulating the policy. So he must have had this in mind, I suppose.
Yes, and it was cited, but the reason, well, I respectfully submit or suggest that the reason why, in a sense, it didn't arise was that he concluded that there was this approach of excluding everything except spatial, which is really linked to the fact that he only looked for the answer in 7.122 of the officer's report, and therefore didn't see the purpose-based analysis as relevant to what he had to look at. But that was an error of approach for the reasons that I've already suggested.
But I mean, it's such a sort of, the question of what does appropriate mean, appropriate to the green belt? Well, in fact, if you look at the history of all this, there's been a sort of consistent policy of defining green belts, but then accepting that certain categories of development are, quotes, appropriate simply because either they need to be in the green belt or they don't harm it too much or they're temporary. All sorts of factors come into account. And this sort of analysis doesn't really help you very much, does it?
My Lord, I agree, see the caveat to this section of my submissions, that it doesn't move matters on from where we were in Mr. Justice Ousley's analysis. So the fourth and final topic, with a degree of trepidation, is the case of Turner. But in fact, again, my submission is that this is just a completely different case. So one very important point. So I think we can go straight to it was decision of Mrs. Justice Lang in the High Court, which was upheld by a Court of Appeal, including my Lord Justice Sales at tab 13 MS 901. But Turner was a very, very different case. So it was effectively the limited infilling exception, which is the sixth bullet point to paragraph 89. And critically, no purpose-based approach to the dwelling was relevant here. It was just a case of what's the approach to openness. And the case that was advanced, so if I can pick it up at...
Forgive me, was it infilling or was it redevelopment of previously developed sites?
It was a mobile home, wasn't it?
I think...
I might be misremembering.
I think it is...
So 901, they were trying to say that the mobile home plus some lorries were not materially different from the house they were going to...
For a three-bedroom bungalow.
It's the last bullet point, I think, my Lord, 906, limited infilling or partial complete redevelopment. So, yeah, and...
You said the infilling bit, so sorry.
I did.
I might have misremembered.
Well, they're in the same bullet point.
Oh,
so
okay.
And I may have slightly mischaracterised it. So
fine. Okay.
The relevant comparison in the in the judgment of the Court of Appeal, paragraph 4, which is MS 905, the appellant compared the proposed redevelopment with the existing lawful use of the land for a mobile home and 11 parked lorries in order to suggest that the volume of the proposed bungalow would be less than the volume of the mobile home and the many lorries that accordingly the proposed development would not have a greater impact on openness than the existing lawful use of the site, with the result that it should not be regarded as inappropriate development in the green belt. So that was the context of the argument on that last bullet point in paragraph 89. And the argument that was advanced, my Lord Justice Sales's judgment, as he then was judgment set out at MS 906, the inspector's analysis, and the developer had urged upon the inspector a volumetric approach of looking at basically aggregating together the volume of the mobile home and the various units and commercial buildings, and arguing that that was the right approach to take. And that was rejected by the inspector because he said in paragraph 12 that there was no valid comparison that could be made, and he decided that would be a considerably greater impact on openness for the reasons that were set out in the inspector's decision, paragraphs 10 to 14, that are on page MS 907. The legal issue that was advanced, which I respectfully say was, again, the example of over-legalisation of the approach, was Mr. Rudd, on behalf of the developer, in paragraph 11 of his oral submissions, advanced the argument. So paragraph 11 of the judgment on 908, he advanced the argument that the inspector had wrongly equated openness with visual impact, and he drew obviously on the Timmins decision. Now, the approach of the Court of Appeal was to identify the issue in paragraph 13. The principal matter in issue is whether the inspector adopted an improper approach to the question of openness of the greenbelt when he made that comparison. The question of the true interpretation of the MPPF is a matter for the court. In my judgment, the approach of the inspector was correct, and the judge was right to so hold. And then in paragraph 14...
Yes. Sorry, go on.
Sorry. In paragraph 14, openness is described as an open texture concept, and a number of factors are capable of being relevant when it comes to applying them to the particular facts of a given case. Now, I'm going to deal with 15 to 26 in a moment, but the basic structure of the decision in this case is inspector's taken an approach, hasn't adopted any kind of legalisation of what openness means. You'll see that from paragraph 11 of the inspector's decision. He's dealing with it as freedom from development, albeit he says operational development, and that's corrected. My Lord Sales says, well, this is an open texture concept. There's a number of factors that are capable of being relevant. And when he then makes the decision in the case itself at paragraph 27, the way that it is expressed is, this is MS 912, turning back to the inspector's decision in the present case, there's no error of approach by the inspector in his assessment of the impact on the openness of the green belt, because those paragraphs make a legitimate comparison of the existing position regarding the use of site with the proposed redevelopment, a matter of evaluative assessment for the inspector in the context of making a planning judgment about the relative impact on the openness of the green belt. That assessment cannot be said to be rational. It was rational and legitimate for him to assess on the facts of the case that there's a difference between a permanent physical structure in the form of the proposed bungalow and a shifting body of lorries. So the way it's expressed is effectively a failed rationality challenge to the application of criteria to an open texture concept. And that's the structure of the decision reached by the Court of Appeal. In dealing with the submissions, there are some observations in paragraph...
And I think, the last sentence of paragraph 27, he's also entitled to take into account difference in visual intrusion.
Yes.
Again, I think you would say, put in terms of entitlement to do this.
Precisely.
Rather than
Precisely.
It's only about that.
Precisely. And so the short point... Sorry.
No, I was just thinking in paragraph 13, when he says interpretation of the MPF is a matter for the court. Now, that was following the Tesco decision, where that's what it's before we get to the Hopkins case, where I tried to suggest that there are differences in the types of what interpretation means, depending on the concept you're talking about.
Yes.
And this is actually quite a good illustration of how the concept of openness is a much broader one than the one. So to some extent, the court's task of interpretation is rather more hands-off, I would suspect.
Yes.
I think that's illustrated by the way my Lord deals with it.
Yes. So my 3 points on, I haven't shown the middle passage where there's a debate about Timmins, but just to kind of cut to the chase, the 3 points I'd make about Turner is, possibly 4 points. First one's one I made. It's actually structured as a rationality decision. Secondly, it doesn't deal with it's a completely different context. It doesn't deal with the real issue in this case, which is the relevance of the purpose of that which is being analysed, which is one of the key issues in the mineral extraction case, see Europa. Thirdly, it doesn't say that, it says the inspector was entitled to take account of visual, not that he was required to, or that there was always a requirement to express a separate conclusion in terms of visual impact. And fourthly, if and insofar as what is actually being said is that you can't sensibly make a judgment about openness without and the purposes of the green belt without thinking about the visual relationship of what is proposed to the green belt. That's actually a point against the respondents in this case, because we know that there is an analysis of the purpose and conformity to that. So if it's implicit in the concept, it must be implicit in the analysis to give effect to the concept. But then I'm not sure in the time I have, I'll greatly assist the court in dealing with the analysis of Timmins itself, because on my primary case, it's of limited relevance for the reasons that I've already identified. But the 2 points I would highlight is, firstly, that it's not a purpose case, I've already said. The second thing is, in paragraph 23, which is part of the observation as to why, if you like, there's a visual element to this, I just invite some caution to sorry, it's not an observation about paragraph 23, it's an observation about paragraph 15. So the proposition that's alighted upon by the respondents and by the Court of Appeal, that visual impact is implicitly part of the concept of openness, which is then a proposition to say, and it was excluded from the analysis in this case because we're only looking at 7122. That derives in the structure of a case where it's one consideration. My Lord rightly and fairly draws upon the purposes of the green belt in reaching that conclusion that it may be implicit. But then I just invite caution about the reference to paragraph 81 to positively planning to retain landscapes, because that's said to be an important part at the point of designating land as green belt. But on the approach in PPG 2, which I say is the MPPF is consistent with, that's not relevant to the decision to designate. That's about taking opportunities once they're designated. So to that extent, it may be that part of the reasoning doesn't truly reflect the distinction between what I would suggest is a more spatial approach of the purposes of visual, of stopping, effectively urban containment as distinct from visual.
To be absolutely clear, you don't quarrel with the notion that it may be appropriate to take into account the visual aspect.
No, because it's a matter of judgment, and it may be, for example, if it's a highly sensitive bit of green belt, the fact you can see it for 7 years might actually make a critical difference, because that separation might be eroded for 7 years, and that in itself might be enough to conflict with the purposes of the green belt and openness. But it's one of the myriad of factors, and in this case, I say the true myriad of relevant factors were considered, and it's utterly unrealistic to say that the officers positively excluded from the analysis any knowledge of the visual effect of the proposal. That simply cannot be right. So,
without wanting to be too overly defensive about my own judgments in relation to paragraph 81, I mean, I think I was seeking to accurately reflect paragraph 81, where I say, retain and enhance landscapes, visual amenity and biodiversity is an important part of the point of designating land as green belt. In other words, you designate first, but once you've designated, paragraph 81 is emphasising the things that you're hoping to get out of green belt. Not necessarily exclusively those things, but those things are part of the point of designating.
Well, but the point, insofar as it is a point, is simply that it's exactly that point, that they're not relevant to the continued protection and the designation, but there is clearly a separate policy to make the most of them in ways that includes visual and access. And my Lord, it's perhaps in any event, the bigger point in the submission of Turner is it doesn't found a proposition that there's a requirement to take account of visual, and it certainly doesn't displace the Europa analysis as the best approach in the present case. So may I, in my remaining, I think, 6 minutes, draw together in the fourth and final part of my submissions why I say the appeal should be allowed and the Court of Appeal's decision is wrong. And I think I've got 7 points I'd just like to make shortly. So the first point is one I've strongly foreshadowed already, that the Court of Appeal's analysis, in particular at paragraph 45 and 47, treats openness, treats paragraph 7.122 as the place where openness is assessed, and that's clearly an unduly restrictive reading of the officer's analysis. My second point is that it doesn't follow from the Turner decision itself that there is a requirement to deal with visual impact. That goes much further than my Lord Sales went in Turner, which was simply properly understood a decision that the having regard to it in the way that particular inspector did was not irrational. The third point is that, which very much echoes of the first point, but the analysis of the High Court at particular paragraph 63 is to be preferred to the analysis of the Court of Appeal in showing that a broader range of considerations than simply purely spatial considerations featured in the decision. And so the whole claim, I say, is built upon a false foundation of looking at paragraph 7.122 in isolation and relying on a false dichotomy between spatial and visual considerations, which isn't supported by even the case law relied upon, and certainly is inconsistent with Europa. The fourth point is there is no need for this court or any court or the Court of Appeal to try to create a prescriptive framework for openness over and above the practical framework in mineral extraction cases already articulated by Mr. Justice Ousley in the Europa decision, which properly mediates between the starting point of the policy and the proviso to the policy, and which I respectfully say a true analysis of the decision-making process in this case shows that the Council adhered to rather than departed from. Fifth, insofar as one needs to do this, if it is right that visual considerations are implicit in any consideration of openness, then those considerations must be implicit rather than excluded from the relevant section of the officer's report, because matters such as purposes, remediation, the Europa factors must have taken account of the visual effect of the proposal. And sixthly, that absolutely must be true in relation to the remediation scheme where openness was specifically referred to, and in the conclusions that were articulated in relation to character. And seventhly, although this is a minor point, the Court of Appeal also wrongly contended or based their analysis in part on the proposition that landscape objection was only because it was offset by benefits, when that actually wasn't the factual basis of the decision.
I'm sorry, could you just give me that last one again?
So the point about the Court of Appeal in paragraph 47 based their conclusion about the landscape objection on it being outweighed by benefits, when, as I tried to show the court on the factual analysis part 1, that wasn't the basis on which the officer's report was written. And finally, so I say that ground 1 of the judicial review should have failed. Mr. Justice Hickenbotham, as he then was broadly right. The Court of Appeal took an incorrect approach. In the respondent's case, they seek to resurrect a ground that hasn't succeeded below, ground 4, which is based on looking at paragraph 7.122 in isolation and saying that there is the reason that openness is preserved is because it's an extension to the quarry. And that is clearly wrong and clearly contrary to the correct reading of the officer's report for the reasons given by Mr. Justice Hickenbotham at paragraph 77 to 79 of his judgment, MS 277, effectively that, as he'd already foreshadowed in paragraph 63, it's clear that a wider range of considerations informed the overall judgment on openness. So that is, if you like, a heightened restrictive focus on paragraph 122, which must be wrong if, as I've already submitted, ground 1 fails. So I respectfully submit that the Court of Appeal was wrong to quash this decision, and that should be overturned because the council's officers lawfully followed the approach to the starting point and the proviso that had been framed very clearly by Mr. Justice Ousley in the Europa case, and that remains the right framework followed in this case, not in need of extra elaboration, and the attempts to create a sharpened and heightened approach by the Court of Appeal was a legal wrong turning and also based on a factual misreading of the decision that's been arrived at. My lady and my lords, unless I can assist with any matter, those are my submissions.
Thank you very much, Mr. Kalinsky. Ms. Gibbs? It's okay, I think you come next, don't you?
Thank you, my lady.
It would be helpful if you moved so that you are situated between the two microphones, if that's all right with you. Yeah. And you might want the lectern.
My ladies, my lords, I think I can take the points in my submissions relatively briefly because much of what is set out in my written case, which starts on MS page 160, has already been covered by my learned friend, Mr. Kalinsky. Just want to emphasise a couple of points and actually pick up and respond to a couple of questions that have been raised by your ladyship and your lordships. Firstly, I just want to comment on the reference made by my learned friend, Mr. Village, at page 135 of the bundle. Paragraph 69 of the written case sets out the recently released version of the PPG. And you'll see there that the first and second respondents seek to place reliance upon the wording of the PPG in this respect for its proposition that the council took a wrong turn in this case. In my submission, the PPG, the wording of the PPG, and in which I stress in particular on page 136 of the bundle, openness is capable of having both spatial and visual aspects. In other words, the visual impact of the proposal may be relevant, as could its volume. In my submission, that actually supports the fact-sensitive approach, the open, textured nature of the concept of openness that Mr. Kalinsky has already invited the court to accept. So in my submission, that does not assist the first and second respondent, but rather assist the appellant's case.
Well, I mean, I'm slightly mystified. We had the NPPF, which was meant to get rid of all the PPGs, and now we're going back to PPGs again, are we?
Yeah, indeed, my lord. Yes, I think there is some general mystification in the profession in planning on that.
Well, happily, that's not a problem for us.
Not today, my lord. Today. So that's just point one that I just wanted to briefly press upon the court. Secondly, just with respect to the error that actually arose from the High Court's decision, which Mr. Kalinsky has already advised the court about, and which was also referenced in paragraph 47 of the Court of Appeal's decision. Just for your reference, that is also set out in terms in the written case for the third respondent, and if it assists, the paragraph reference, if you need it, whilst deliberating, is paragraph 52, which is MS page 176. And as Mr. Kalinsky has already rightly pointed out, actually what the officer concluded in the reports committee was that this development was compliant with the development plan. It did not conclude that there were harmful impacts to landscape that had to be outweighed by social benefits. And that is, of course, an important distinction. And unfortunately, that has somehow gone wrong along the way. And the Court of Appeal in paragraph 47 does rely upon that to some extent, and it needs to be corrected. Thirdly, just in response to a point raised by my Lord Justice Sales, my Lord raised the point of whether or not, if one looks at paragraph 7122 of the Officers' Report Committee in isolation, did it exclude visual dimension? My submission on that point is it clearly did not. And indeed, I deal with that particular issue at paragraph 55, Roman numeral 5, which is on MS page 177 in my written case. Actually, sorry, I think I've got the reference slightly wrong there. It's actually paragraph 55, numeral 2. The officer's report did not advise members that visual impact could not be taken into account. And then I go on at Roman numeral 5 on the same page of the bundle, so we're still on page 177, where I, in response to points raised by the President and others in discussion with Mr. Kalinsky, in my submission, the words scale and the words character do clearly have a visual dimension, and the visual dimension of openness was therefore clearly taken into account, and I set that submission out at page 177. It is a false dichotomy to suggest in this case, on the facts of this case, that scale could have been considered properly as set out by the officer's report without having regard to those visual impacts. It wouldn't have made any sense. And then I believe the only additional submission that I think I need to draw to the court's attention, if I could ask the court to take up page 168 of the bundle. And it's my paragraph 27 of the written case for the third respondent, where I mention that visual impacts do almost invariably arise from undertaking mineral extraction, and they are commonly and generally found in mineral extraction, as the President has noted with respect to the area within which she lives. And this, of course, goes back to the points being made by Mr. Justice Ousley in the Europa case about how paragraph 90 of the framework has to be applied in a practical framework, looking at real-world scenarios, not looking at fanciful situations. Now, there's a submission in the written case for the first and second respondent that's relevant to this particular point, and it's found at page 140 of the bundle. It's paragraph 81. It's the point that's already been mentioned in discussion by my ladyship and my lordships regarding underground mineral extraction works. In my submission, the point made on behalf of the first and second respondent here is tantamount to an argument that open cast mineral extraction cannot be, as a matter of principle, appropriate development in paragraph 90 terms. Now, of course, the court's already heard submissions on that point, or in connection with that point, from Mr. Kalinsky. However, I would like to add that if paragraph 90 was not capable in principle of applying to open cast mineral extraction, and as a result, open cast mineral extraction could never be appropriate development in the Greenbelt, it would have been incredibly easy for the framework to have said so, and it
just
does
add the
not.
word open cast.
Exactly.
Or add not open cast.
Exactly,
Yes.
my lordship. It would have been extremely straightforward to just exclude it if that was indeed the intention of the framework. And of course, when one looks at the recently published PPG that's also referenced in the written case, the first and second respondent, that exclusion is not included there either, and that's the most recent publication of the government's own interpretation of what it thinks paragraph 90 does. So, just to wrap up those points, I don't think there's anything else that I need to take the court to. The third respondent wholly and completely supports the appellant's appeal in this respect and respectfully requests the court to uphold the appeal for the reasons given. I don't need to take any more time unless you have any questions for me.
No, thank you very much indeed, Ms Ogden. Thank you. Mr Village.
May it please the court. My lady, my lords, leaving aside the jargon that comes with planning, the interpretation of policy is ultimately a matter of law for the courts. But there are some very clear principles of interpretation which are not in dispute, and a key one of that is of giving words their ordinary and straightforward meaning. Like other parts of the Greenbelt around England, Scotland and Wales, and in particular in Yorkshire, the Greenbelt is an essential planning tool to keep, for example, towns from merging one into the other.
Why is it different in Yorkshire from anywhere else?
No, it's not.
We've got an awful lot of green space in Yorkshire.
Well, can I just deal with the lot of green, the lot of mineral working that you have seen around Richmond, which will have been permitted on the basis of very special circumstances because of an identified need at the particular time. But
well, sand and gravel is always needed, isn't it? For building
not
purposes.
in this case, and certainly no case was put by Darrington that very special circumstances existed for this development. And that is why the...
Sorry, how do we know that
Yes, how do you know that?
the Yorkshire quarries have been based on need?
Well, the submission I'm making, actually, my lord, is simply confined to this case, that in this case very special circumstances have not been...
No, I mean,
Well, we haven't got on in this case to the very special circumstances test because the decision which you challenged was one that you didn't, which didn't need to go that far. So you say...
It wasn't put forward on that basis
Yes.
by Darrington.
No.
They could have, if there was a need and if it existed, they could have identified very special circumstances based on need, but they didn't. And so the threshold question...
we can't speculate about quarries in Yorkshire may have been based on need or not. We just don't know.
Well, I was simply picking up a point that my lady made earlier this morning. But I...
Back to Tester.
Going back to this case, the threshold question was simply in relation to whether or not the development was appropriate or inappropriate development. And if it was appropriate, very special circumstances would not be required. And if it was inappropriate, very special circumstances would be required.
But even if it's, quotes, appropriate, you still have to go through a proper planning judgment as to whether on its merits it should be permitted or not.
Indeed. If one starts, picking up again the question as to what point of law of general public importance is raised in this appeal, I would suggest that it is the meaning of openness. if one starts with that basic principle, this is really a very simple case indeed. First of all, there is no dispute that the development falls within the description of mineral extraction, paragraph 90 of the framework, and forms part of a closed list of development which is potentially appropriate within the greenbelt, provided the development preserves the openness of the greenbelt and does not conflict with the purposes of including land in the greenbelt. Mineral extraction development in principle is capable of covering an extremely wide spectrum of different types of activity that will necessarily have very different effects on the land and consequently the openness of the greenbelt. At one end of the spectrum, it can cover mining, which is entirely underground, with any surface working entrances outside the greenbelt or potentially using entrances which already exist. At the other end of the spectrum, it can include open cast mining or extraction on the surface with very severe and obvious effects on the greenbelt itself. And paragraph 90 requires openness to be preserved, that is to say not harmed, for mineral extraction to be treated as an appropriate development. So, as I say, the central issue and the appeal turns on the meaning of openness expressed in paragraph 90. The term openness is a critical term about which there really shouldn't be any room for doubt if greenbelt policy is to have a simple and straightforward meaning and to be applied consistently. It may be fair to say that the term openness has some aspects to it which are not as straightforward as others. So freedom from development, including built form, is one such aspect that's been described as a spatial aspect. Openness is not preserved by development which is hidden away from view. And in this respect, the Court of Appeal identified in Turner that the term openness is therefore open textured, and it includes this spatial aspect. But in addressing this important,
I think very strictly, one, if you wanted to, could distinguish two spatial aspects. One is spatial on the map. Are you infilling between towns or leaving green corridors and spaces between them? And the other, which was more the issue in the Turner case, is the sort of the volume of the building that you're putting in place.
Yeah. Well, if I may say so, and obviously the judgment in the Court of Appeal with which Lady Justice Arden and Lord Justice Floyd agreed identifies in what we say is a very, and forgive me, my Lord, but entirely correct and sensible and straightforward way, the terms of the meaning of openness in a general sense. And one can see that, and I invite the court to look very carefully and read very carefully paragraphs 14 to 16 of Lord Sales's judgment in Turner, and at page MS 908 and 909, and also in particular the court's conclusion at paragraph 26 of Turner on page 912. Because reading those paragraphs, it's clear that, and of course I take the point, obvious point, which is that this was a case where it was being said by the claimant, well, visual impact is not a relevant consideration, and the courts concentrated on whether or not it was. But there are some more important points which one finds in Turner, not least that Lord Sales dealt with and explained why Mr. Justice Green in Timmins was wrong. And I draw particular attention at paragraph 26 of Lord Sales's judgment where he says he thinks that Mr. Justice Green erred in Timmins in taking the Heath and Hampstead Society case to provide authority for the two propositions he sets out at paragraph 78 of his judgment, to which I've referred above. And referring above is to the reference at paragraph 17 of Lord Sales's judgment, where he takes issue with what Mr. Justice Green said, that there is a clear conceptual distinction between openness and visual impact, and it is therefore wrong in principle to arrive at a specific conclusion as to openness by reference to visual impact. Now, the explanation for that is given in paragraph 18 of Lord Sales's judgment, and it is, if I may say so, completely correct. But going back to the importance of this judgment in identifying openness, it's to be found in paragraphs 14, 15 and 16, and in particular 15. The question of visual impact is implicitly part of the concept of openness of the Greenbelt. As a matter of the natural meaning of the language used in paragraph 89 of the framework, I consider that this interpretation is also reinforced by the general guidance in paragraphs 79 to 81 of the framework, which introduced section 9 of the protection of Greenbelt land. There's an important visual dimension to checking the unrestricted sprawl of large built-up areas and merging of neighbouring towns, as indeed the name Greenbelt itself implies. Greenness is a visual quality. Part of the idea of the Greenbelt is that the eye and spirit should be relieved from the prospect of unrelenting urban sprawl. It goes on, 16, the visual dimension of the openness of the Greenbelt does not exhaust all relevant planning factors relating to visual impact when a proposal for development in the Greenbelt comes up for consideration. And then Lord Sales explains what other harms there may be. So from that understanding of openness, which the Court of Appeal below in this case entirely endorsed, one can see that visual impact is one of the component parts of openness. It is like the spatial aspect of openness, just as important. There may be other factors which might be described as the Europa oil factors, but we needn't get into those for the purpose of this. But I mean, for example, in the Greenbelt, it's not just spatial, it's not just visual, but it is also, in my submission, oral. So if one can hear, for example, a road, it is another aspect of the impact on openness. And as to that, I mean, my Lord Carmworth will, of course, know as anyone, the correctness of that proposition, but it's been most recently re-emphasised by the government in their planning policy guidance note, which now is entirely online and replaces lots of circulars and PPGs and so on, and that has been produced. It's part of our case.
Sorry, which one is this? You say I know about all this. I big assumption. I wasn't aware that noise was identified as a relevant Greenbelt factor, but maybe it is somewhere.
Well, I obviously can't say what you persons of
forgotten perhaps. Anyway,
attempt to do.
Where is it now? Where does one find now a PPG which talks about which you're wanting to refer to? I mean, I was just looking online. I see they now produce a whole lot of sort of mini PPGs, which seem to deal with various aspects of planning policy. One is on green belts, but I don't think we've got them in the bundle, have we?
Is the document you've just been referring to, is that the latest planning practice guidance?
It's, yes, my
July
lord,
2019.
it's at paragraph 69 of our case, page 135.
Right.
This is a PPG, but it's a planning practice guide, is it wrong? Planning policy guide.
Planning practice guidance, it's called. But do we have this in the bundle, or do we just have the reference in your case?
I'm sorry,
I'm so sorry, Mr. Village. Do we have this document, which is referred to here, in the bundle, or do we just have this reference from your
just
case?
have the reference, my lord. We can obviously provide it if that would be of assistance.
But does it talks about the degree of activity likely to be generated, such as traffic generation, but in another passage, does it refer to the oral impact, hearing the traffic?
No.
Where do we get that from?
I have to say that is it's not set out in there, my lord, and we're not, and made it clear below that we're not pushing any point about oral, but I was simply identifying in general terms that there are a number of factors, being spatial, visual, and also what one might call cred-NZ factors, such as duration and restoration, all of which go to issues of openness.
Well, duration goes to openness because the NPPF emphasises in paragraph 79 permanence and openness and treats them as part of the same concept.
Yes.
Yes.
So, in this case, it was the failure of the council, advised by its officer, to consider the visual effect of the development on openness, which is key. And I emphasise this, members were not even told it was a potentially relevant consideration. The officer's report was silent with respect to visual considerations when considering the effect on openness. And it's those failures which led to the Court of Appeal concluding that the Council misconstrued paragraph 90 of the framework. Now, before we go much further, I just want to deal with one matter which has arisen as a result of Mr. Kalinski's submissions this morning. And that is the Council has always previously accepted, and the courts below, in the High Court and the Court of Appeal, have found that the Council's officer did not take visual impact into account when considering the likely effect of the development on the openness of the Greenbelt. One can see that in a number of places. Firstly, the Court of Appeal's judgment at paragraph 27, when recording Ms. Stevens and MS 245, when recording Ms. Leven's submissions, Lord Justice Limbom said the officer did not take visual impact into account when considering the likely effect of the development on the openness of the Greenbelt. But at that stage, she did not have to repeat the advice she'd already given on landscape and visual impact. So that was the submission in the Court of Appeal. But in fact, it was no different in the High Court, because if one turns to paragraph 16...
Sorry, what are you saying about that? I mean, she's saying that she doesn't deal with visual impact specifically at the time under the section marked openness.
Yes,
she had already
doesn't deal with...
Had already dealt with it in relation to landscape.
Well, she says that visual impact was considered under the heading landscape,
yes,
but it wasn't dealt with when dealt with when dealing with the issue of Greenbelt.
But are you saying that Miss Leaven was suggesting that she sort of, planning officer somehow put it out of her mind when dealing with openness, or?
Well, no, but as I'll go on to explain, what might be a highly beneficial effect in landscape terms is in fact a harmful effect in greenbelt terms. And there's a very obvious example of that, which is in the officer's report, which we'll come on to after the short adjournment. But
sorry, just on this, Mr. Village, we've been addressed by Mr. Kalinsky, taking us to the officer's report itself, saying that actually visual aspects were taken into account by the officer's report. I mean, surely we're not bound to go by what may have been accurately or inaccurately recorded by the Court of Appeal as to what Ms. Leaven said below. Why don't we look at the report itself?
Well, I mean, it is, I think, a fair point to say that Mr. Kalinsky's case has changed indeed today, because I'm after, again, take you to what his case was, his written case is before the court. I appreciate that he says that it was taken into account, and I will come on to deal with why that is incorrect in due course.
Yes.
But, I mean, the factual position is, in the High Court in front of Mr. Justice Higginbotham, as he then was, recorded at paragraph 65 of Mr. Justice Higginbotham's judgment, MS 275, it is clear that the council's case was that it wasn't taken into account when assessing openness. The whole point of the argument was that it proceeded on a different basis, that it didn't have to take it into account. But
sorry, where are you reading from now?
Paragraph 65.
On page 275.
On page 275.
Yes, the fact that he's saying that it fell short of being an obvious material factor.
Yes.
That's only relevant if it were being asserted that it wasn't taken into account. Yes.
Mr. Village, I've got my eye on the clock, and I hope that that's a convenient moment for you to pause in your submissions.
Yes, and if I can actually wrap up this last point by one more reference, which is to the Court of Appeal's argument in the Council's argument in the Court of Appeal at paragraph 20.
Thank you.
My lady, thank you.
We will adjourn now and resume at 2 o'clock.